The Supreme Court of India continued hearing the batch of petitions challenging the Karnataka High Court's verdict which upheld the ban on wearing of hijab by Muslim girl students in educational institutions in the state of Karnataka. The matter was heard by a bench comprising Justices Hemant Gupta and Sudhanshu Dhulia. The arguments today were made by senior advocate Devadat Kamath and advocate Nizam Pasha appearing on behalf of the petitioners. Kamath's submissions today pertain to various facets such as Article 25 of the Constitution, which stipulates the freedom to profess one's religion, application of the heckler's veto in India, bona fide practice versus belligerent display of religion, difference between freedom of conscience and religion, and whether the impugned government order was administratively sound. Whereas Advocate Pasha's argument centered on how the wearing of hijab is an essential religious practice and is therefore protected under Article 25 of the Constitution of India. Interestingly, at the outset of the proceedings today, Advocate Pasha stated while addressing the bench that Kamath was a student of Hindu law and he was a student of Islamic law. In this video, we will have a look at all the arguments that were made and the exchanges between the bench and the counsels in detail. We have also covered in detail in our earlier videos the arguments advanced by the concerned parties and the courtroom exchanges that took place during the prior two hearings. The link to the videos have been given in the description box below. Please do check it out. So without further ado, let us find out what transpired in the Supreme Court today and what exactly were the arguments made on behalf of the petitioners. Advocate Nizam Pasha today focused on the scriptures and injunctions in Islamic law regarding the hijab. However, before referring to the scriptures, Pasha gave a word of caution to the bench, which was resounded by the 5 judges bench in the Babri Masjid judgment of the Supreme Court. He stated that in the Babri Masjid judgment, the court did not enter into an area of theology by stating that the true test was to see if a true believer holds that belief. Thus, as per the judgment, the court must steer clear out of adopting one among the many interpretations of theological doctrines. Pertinently, Pasha today argued that the High Court had misinterpreted Islamic verses to hold that the hijab was not mandatory. He submitted that the High Court had referred to an unrelated verse which stated that nobody can be compelled to convert to Islam to hold that hijab was not mandatory. At this juncture, Justice Gupta asked Pasha to show the bench the verses holding hijab as necessary, following which he referred to the Surah An-Nur ayat 31 of the Quran. While drawing the attention of the court to the footnotes of the High Court judgment, Pasha further stated that the High Court had referred to the opinion of a translator and not the translation of the text itself. He stated that the footnote in question was concerning the verse about jilbab, which covers the whole body, as opposed to the hijab, which only covers the head and the chest. Thus, the author, as referred to by the High Court, had stated that the jilbab was not compulsory. To prove that the hijab was necessary, Pasha referred to Surah 24. Accordingly, Pasha contended that it is on this particular misreading of the particular footnote that the High Court had concluded that wearing of the hijab is recommendatory and not mandatory. He further submitted that the High Court had held hijab as not mandatory due to the absence of any prescription of penalty. Refuting such a conclusion of the High Court, Pasha today pointed out that there is no temporal punishment for a spiritual disobedience and that religion has implications for the afterlife. He submitted that even for the violation of the namaz or the roza, there is no temporal punishment prescribed in the Quran. He underscored that the Quran is the word of God and belief in the word of God is the first precondition for being a Muslim. Significantly, Pasha today argued that the Karnataka High Court judgment upholding the hijab ban bordered on being blasphemous. He contended that the High Court, observing that with the passage of time certain verses of Quran have lost their meaning, is blasphemous. He emphasized, and I quote here from his submissions, "For believing Muslims, Quran is perfect for all the times to come. So to say the verses have lost meaning with time is bordering on blasphemy." He then went on to state that the High Court judgment holding that the hijab was at best a cultural practice is incorrect. However, he continued his line of argumentation by submitting that as per Article 29, Clause 1 of the Constitution, even cultural practices are protected. To elucidate his argument, Pasha provided instances of how the Sikhs have to wear a turban and that Sikh boys wear their turban of the same color as that of the uniform, and that it has been established that this will not in any way cause indiscipline in schools. He argued further that just like the turban, even wearing of the hijab is regarded as cultural and must be protected. Justice Gupta was however quick to dismiss this argument as irrelevant by stating that the comparison with Sikhism was improper. He said, and I quote, "The comparison with Sikhs may not be proper. The 5 Ks of Sikh have been held to be mandatory. There are judgments. Carrying of kirpan is recognized by Constitution, so don't compare practices." Justice Gupta further stated that practices of Sikhism were all well established and ingrained in the Indian society. He said, and I quote again, "Please don't make any comparison with Sikhism. These are all practices well established, well ingrained in the culture of the country." To this, Pasha however responded saying that Islam as a religion is 1400 years old and even hijab is an established practice. Justice Gupta had in earlier hearings also remarked that pagri was not equivalent to a hijab and that the two could not be compared. Likewise, he had also stated that the chunni was also not comparable to a hijab. Now let us find out what were the arguments advanced by senior advocate Devdutt Kamath. Yesterday during the hearing, senior advocate Devdutt Kamath, appearing on behalf of the petitioners, had argued that the government order banning hijabs in educational institutions were not innocuous as argued by the state, but in fact violated the fundamental rights of students under Articles 19, 21 and 25 of the Constitution. To substantiate this further, he had relied heavily on the judgment of the Constitutional Court of South Africa titled KwaZulu-Natal and others versus Pillai, pertaining to the right of a Hindu girl from South India in wearing a nose ring. The bench had then asked him how parallels could be drawn between India and South Africa and what provisions existed in the South African Constitution regarding this issue. Today, Kamath commenced his arguments by stating that the bench was right in pointing out that since South Africa is much more diverse, the scope of protection is wider. He then went on to point out a judgment of Austria where a selective ban on headscarves targeting one community was declared unconstitutional. Referring to the freedom to propagate one's religion as enshrined under Article 25 of the Constitution, he argued that the state had not justified the restriction of hijab in schools either on the ground of public order or morality or health, which are the reasonable restrictions that can be imposed upon fundamental rights. He also pointed out that the state's argument that a headscarf would offend other people could not be a reason to ban the hijab. At this junction, Justice Dhulia reminded Kamath that the argument under Article 25 of the Constitution would be available to him only if he was arguing that hijab was an essential religious practice in Islam, but that in the last hearing, Kamath had stated that he would not be using this line of argumentation. Responding to this, Kamath clarified that the right falls within the purview of Article 19 as well as Article 25 of the Constitution, and that every religious practice may not be essential, but that does not mean that the state can keep restricting it, that is, as long as it does not fall foul of public order, morality or health, which are the reasonable restrictions. Citing an example, Kamath pointed out that senior advocate K. Parasaran, who is like a father figure, wears a nammam and thus remarked if that in any way affects the discipline of the court. However, Justice Gupta interjected at this point and stated that dress code in court could not be compared with the instant case. Justice Gupta also stated that wearing a hijab in the streets may not offend anyone, however wearing it in a school might, as the question was about what kind of public order the school wanted to maintain. Kamath then proceeded to introduce the concept of heckler's veto in his submissions. For context, a heckler's veto refers to the suppression of speech by the government because of the possibility of a violent reaction by hecklers. The First Amendment of the United States holds heckler's veto as unconstitutional. In his arguments today, Kamath attempted to establish that the Indian courts had applied heckler's veto in their decisions. He pointed out that the Advocate General of Karnataka had argued earlier that the impugned government order had been issued after some students demanded to wear saffron shawls and that the ban was imposed in this particular context. Kamath further stated, and I quote here, "Can heckler's veto be allowed? You, that is the state, can't take a facile ground that public order will be violated. It is your duty to ensure an atmosphere of public order so that I can exercise my rights freely." Kamath then proceeded to make arguments under Article 25, Clause 2 of the Constitution. For those of you who are not aware, Article 25, Clause 2 of the Constitution states that the state can make laws to ensure social welfare and reform in a religion, and that would not violate citizens' fundamental right to profess one's religion. If I wear a headscarf, whose fundamental rights am I violating? Kamath contended today during the hearing. At this juncture, Justice Gupta remarked, and I quote, "It is not the question of violating others' fundamental rights. The question is whether you have the fundamental right." He further referred to the provisions of the Karnataka Education Act of 1983, under which the Karnataka government had issued the impugned government order. Kamath highlighted how Karnataka Education Act does not specify any restriction on hijab. While continuing his arguments on whether wearing of hijab can affect public order, Kamath underscored that any restriction on fundamental rights on the ground of public order must have a direct and proximate link with public order and could not be indirect or inferential. Substantiating his arguments, Kamath importantly pointed out that Article 25 of the Constitution protects bona fide practices of religion and not belligerent displays of religion, such as wearing of orange shawls by students in retaliation. The argument of the state is, I wear hijab, other students will wear orange shawl. Wearing of orange shawl is not a genuine religious belief. It is a belligerent display of religion, that is, if you wear this, I will wear this. Article 25 only protects innocent bona fide practice of religion. Wearing a namam, yes. Wearing a hijab, yes. Wearing of orange shawl is not a bona fide practice. Referring to the Karnataka High Court's judgment, Kamath pointed out that the High Court had said that the freedom of conscience was distinct from religion, and that while doing so, the High Court had quoted from Dr. Ambedkar from the Constituent Assembly debates. However, Kamath emphasized today that in the Constituent Assembly debates, there has not been a single word uttered by Dr. Ambedkar on the distinction between conscience and religion. He argued that the High Court had gone into a dangerous territory of separating conscience from religion. To elucidate his point, Kamath pointed out an instance from his own personal life, and I quote from his submissions today from the hearing. Hindu religion provides for 16 forms of puja. Today somebody lights a diya. Is it freedom of religion or conscience? People carry photos of Ram or Krishna. I do. It gives a sense of confidence. Is it religion or conscience? It is not something ordained in the scriptures. Referring to the government order that had prohibited the wearing of hijab, Kamath pointed out that none of the judgments mentioned in the government order prohibited the hijab. He also argued that the government order suffers from a complete non-application of mind and that the High Court could not have supplied reasons for the government order. It is a settled law that the court cannot supplant reasons, and High Court has done so in this case, Kamath argued further. Pursuant to these submissions, the court adjourned the hearing to September 12th, that is on Monday. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates. If you like our content, please do not forget to like and subscribe to our YouTube channel.